Good afternoon and welcome to the last panel of the day, National Security in Orbit and Beyond. So it's really great to be able to gather and talk about matters of mutual interest and concern as the phrase goes in some places. I'm pleased to introduce our panelists. Their participants are people who work in the area of national security space daily, and many of them for many years. I believe you have access to their biography, so you can peruse those at their leisure. What I've asked each of them to do is to introduce themselves and to provide you with 3 interesting professional biographical facts. So if we can start down there with you, Damon.
Yeah, absolutely. So my name is Damon Richardson. I'm the Director of Space Systems and Programs in the Acquisition Division of the Department of the Air Force Office of the General Counsel. A couple, I guess, biographical details. I'm a former active duty Air Force officer and scientific analyst before I went to law school. And while I've been working in the Air Force General Counsel's office, I guess some highlights on things that I've worked on have been helping to work on acquisitions to reintroduce competition into the national security space launch area. Our office has been heavily involved in that, and that's been a real success, I think. And then also helping with the stand-up of the Space Force, and in particular, Congress, when they stood up the Space Force, created some unique acquisition sort of oversight structures, and helping to flesh those out and figure out how we're going to implement those and organize the Department of the Air Force, and in particular, the acquisition function as we're creating the Space Force. It's also been something that's been very interesting that I've been working on.
Thank you. Colonel Todd Pennington.
Thanks, Vita. So I'm Todd Pennington. I'm the Staff Judge Advocate at U.S. Space Command at Peterson Space Force Base in Colorado. I've been on active duty in the Air Force for about 24 years, and the very little of that time in the space mission. For my biographical nuggets, I thought I'd point to the 3 grand chapters as I think of them in my military career. I spent about 9 years supporting special operations units. That's actually where I met Commander Antoine Jenkins of the United States Navy many moons ago, and worked that, as I said, for about 9 years doing special ops. My second chapter was actually in the nuclear weapons and counter WMD, counter proliferation fields, which I also did for about 9 years. There was some intersection of those years, and it was only after I had kind of tied a bow on my time there that the Air Force asked me to go out to, at the time, Vandenberg Air Force Base, because Space Command was going to be established. I assured General Rockwell in the strongest possible terms I did not know anything about space, and perhaps he might consider one of the many LLM graduates and veterans of that mission area. And he assured me, I just need somebody who understands what's going on in the joint world and the Pentagon to get the Space Command thing going. And I professed that I thought I could pull that off, and so far it's working.
Thank you. Mr. James Bennett, please.
Thank you. I am currently Chief Regulatory Officer for Immortal Data Inc., which is a startup based in New Mexico, developing survivable black boxes for spacecraft, which we think is going to be an interesting market for the next coming segment of the commercial space world, and even others, non-commercial space world. But I have a long history in the commercial launch field, starting out as co-founder of 2 of the early rocket companies, Arc or Starstruck, and American Rocket Company in the 80s. We were one of the very first to attempt the private construction, development, and launch of orbital space launch vehicles. Getting funding was a bit dicey back in those days, but I was young and highly optimistic. And I would told the venture capitalists that I thought, even though there was, at that time, there was no legislation or regulation about private commercial launch, that we thought that was no obstacle to eventually doing it, and that we could influence the development of the field in a favorable fashion. So one of my first highlights was getting the first money investment from a Silicon Valley successful person. They gave it to me, and I was VP for regulatory affairs. So I got on the plane to Washington. And the next morning, I got there and they said, I actually don't have the slightest idea how I'm going to go about this. And so I spent the first morning just wandering around the Capitol and just like doing the whole Washington thing, kind of getting inspired. And then I started calling the people I did know in Washington and started explaining it. And one of the first was Dana Rohrabacher, who was at that time the speechwriter at the White House. So he said, oh, I think that's a great idea. Call these people. And you know how Washington works. A couple of years later, I was actually sitting in the House of Representatives testifying on the first bill, Commercial Space Launch Act of 1984 from Congressman Akaka, and saying, oh, I feel like Mr. Smith goes to Washington or something. So that was one of the first highlights. Second highlight happened at Vandenberg Air Force Base, as it was then. For my second company, I was sitting in the launch officer's chair, and the highlight was pushing the button to launch the first piece of hardware that we had designed, built, and operated ourselves. That was a highlight. 30 seconds later, the low point came when I had to start thinking about how I was going to conduct the press conference announcing the failure of the mission. That's the rocket business. So with all the ups and downs of the business, so to speak, I have been involved both on the space launch side and on the spaceport side. One of the things we do is we're a consulting company as well as a development company. And I'm principal investigator for the FAA master plan update for an airport that wants to become a spaceport. So I'm having fun with those issues as well. And the main point of what I'm going to talk about is the interaction between the commercial launch industry and the national security sector in all of its forms. And one final anecdote was the security sector has spent a long time getting used to the idea of private people developing and launching rockets, not on government contract. And one of the first things that happened was they said, we'd better have you at the Range Commanders Council meetings, because that was basically all of the federal spaceport managers getting together and talking shop. They said, well, you're launching from the open ocean, so you're not at a spaceport, but you are launching, and you need to interface with the NORAD, so come out to Colorado Springs. And then they said, all right, give us your security clearance information. I said, we don't have any federal contracts, so we don't have any security clearances. And they said, well, the whole thing's conducted at a security level. And I said, does it have to be? And they said, we'll get back to you on that. And finally, they came back and said, actually, all the sessions except one don't really need to be classified. So we're putting those open, and you'll just have to go stand in the hall for the one that is. And you can stand out there with the Canadians, because it was also no forum. Fortunately, I grew up around Detroit, so I could talk hockey, so it wasn't too boring. Anyway, that's me.
Bart, if you could introduce yourself.
Hi, everybody. I'm Bart Wager. I'm an Associate General Counsel with the DoD Office of General Counsel for International Affairs. My three career highlights, I feel obligated to mention Vandenberg Air Force Base, since everybody else is. I was assigned there on active duty, and in 2002, one of my highlights was deploying to the Kingdom of Saudi Arabia, Prince Sultan Air Base, where I served in the Combined Air Operations Center, providing legal advice to the commander as we determined actions that we could take consistent with rules of engagement that were set up. And one of the really harsh things, I have friends who are Marines, and they talk about, when they deploy, they sleep in tents. Some of my Army buddies, the difficult thing for me is when I was in Saudi Arabia for 3 months, they threatened to close the omelet station. Now, the good news is they didn't close it, but it was a near thing. The next thing was in 2008. Some of you might have heard of Burnt Frost or USA 193, which is a national reconnaissance office satellite that was tumbling out of control, and it had hydrazine on it. And the concern was that if it crashed to the ground with the hydrazine, that could spill, and hydrogen is toxic and damage people. And so the president determined that we would punch a hole through it while it was in space still. And there was a whole lot of discussions, policy, legal, and amazing amount of technical stuff, of course, to get that done. And one of the, and I was sort of the DoD lead for that. And one of the big issues is related to Article 9 of the Outer Space Treaty, which we'll talk about in a little bit, but that calls for, you're supposed to do international consultations if you're going to, the state party is going to do something that would cause potentially harmful interference with the activities of another state party. And so if we're going to punch a hole or blow up potentially the satellite, do we have to do international consultations? We ultimately decided that we didn't have to, but we did those consultations nonetheless. And I remember talking to my ex-wife, wife at the time, and she was like, what are you working on nonstop hours? And I said, wait a day or two and you'll know. And then it went from incredibly highly classified to a public announcement, just like that. And she's, I know what it is. That was not the cause of our divorce. And then third, broadly speaking, I get to participate in drafting and reviewing a lot of interesting things, such as presidential documents, legislation. And part of what I was able to work on are the presidential directives under the Trump administration leading to a directive to tell DoD to draft legislation to create the Space Force. So that's what we did. The Space Force was eventually created, and as was U.S. Space Command was reestablished. So it was really very interesting to be able to participate in that process. And as I was putting these things together, I noticed that one of a theme of them is being able to see results. So when I was working in CAOC in 2002, I could see results very quickly if action was taken. In the USA 193 thing, I saw results within a month or so of starting to work on it. And then, of course, when you're starting to talk about drafting and working on presidential documents leading up to legislation, that can take extra time, but results were eventually had. So thank you.
And Bart told me that I had to at least provide some highlights. As you heard, I was in the Navy before I'm currently also at the Department of Defense, but I'm in the intelligence division, and my portfolio does include space. So highlights of my professional highlights is that in 1992, which was before the legislation that authorized women to be on combatant ships, I got temporarily assigned to the amphibious group going to the CENTCOM area of operations and to Somalia, and was involved in the Somalia operations there. I was literally the only woman on the ship with about 2,500 guys for 6 months. It was both professionally fascinating because it was the first time since the Korean War that we had done the types of operations under the UN charter that we did in Somalia. And being at sea as the only woman was a unique and interesting experience. I also like to point out as a professional highlight that I drafted language in the statutory language which authorized military travelers who were using commercial air travel to retain their frequent flyer miles, and Congress passed that. And so you're welcome. And finally, for the last 3 years, along with Bart and frankly, Damon and other folks here, we have been involved in a really massive effort to change the architecture for space operations within the Department of Defense, and there are resultant changes to the national security space architecture, not just in DoD. There are follow-on effects. I will say that the major failure that I can point to in that is that the legislation does not use the appropriate ranks. Anybody who has read any space opera or watched space shows, it's captain, hello, it's not colonel. Every time an admiral, every time the legislation came across my desk, I changed it, but I was miserably unsuccessful in the end. But you know, time is my friend. We'll be working on that some more. So, unfortunately, as you may know from the program, Deb Plunkett, who was supposed to be here, has been unable to join us because she unfortunately came up positive with our favorite disease. So she was a huge organizing force for this panel, and we thank her, but we're going to have to press on without her. So I'd like to ask the panel first to talk a little bit about, so what does a national security space lawyer do? Just what is the nature of your practice? And who's your client? Let's start with Todd.
So to describe our practice, I think of my client as General Dickinson, the commander, but really all of the staff is our clients. And so everything that staff is doing is reflected in our legal practice. There's a division that addresses our future requirements. And it's not a huge legal lift for us, but we help them navigate how they submit those requirements, then go back to the services, they develop systems. And that's part of the early stage development of developing systems that comply with the law of war, in addition to other technical and operational requirements that come along. Every operation that we do, we're involved in providing legal review on that. And that extends from the current operations, things are happening today, the decision needs to be made. We'll provide advice on whatever that is. We can look around and see things in the news and tell that we need to be ready to do something, or we get told, hey, give us options for if this scenario or that scenario happens. That can become a good deal more adventurous, and we'll provide legal review on that. Many of those things never come to pass, but they can devote a good deal of time to towards the legal review and towards the operational planning. And then further afield, we support the different exercises the command does, where we exercise stuff that we don't even have today, capabilities that we anticipate having in the foreseeable future, and we'll plan with those capabilities. We'll have an adversary red team represented in the command to simulate an adversary actor with the different moves they may make in a conflict and practice our operation. So every sort of time horizon you can imagine, we spend time devoting legal analysis and legal research and writing towards that, even though much of it never comes to pass in real life, or may not for many years, or even generations to come. That's the space law side of my portfolio. It's easily the most exciting and the most interesting to me, but it'll be no surprise to any of you who've worked as corporate counsel or sort of in any kind of a general counsel function for an organization. But there's employment issues, there's investigations for misconduct, there's fiscal issues, there's conflicts of interest questions about different personal financial interests. All those things occur at Space Command, just like at every other DoD organization and frankly, every organization in the executive branch. And me and the legal team at Space Command are That's part of our space law practice.
Sure.
Address the same.
So ultimately, my client is the Secretary of Defense. I don't have interaction with the Secretary of Defense on any sort of regular basis, but my organization within OGC, International Affairs, our primary client is the Undersecretary of Defense for Policy. So my main interactions are with people within the Office of Undersecretary of Defense for Policy. And clients drive the practice of law. So what I do depends on what my clients are doing or want to do. And I think there's really two ways to think about how I can serve my clients. One is in a reactive way, and one is in anticipating or a proactive way. In a reactive way, of course, they come to me and say, hey, we want to do this, can we legally? And so then part of my job will be to review what the idea is it consistent with international law? Is it consistent with domestic law? Is it consistent with established policy? And I can provide that legal advice. And then we also provide policy-related advice, making sure to let the client know, though, if we're providing policy advice, then that's what we're doing. That particular bit is a recommendation rather than a legal requirement. And then, of course, in anticipating what's coming up, you need to get to know the client, understand where they want to go, and then if I, as the lawyer, see a way that it can advance what their goal is without, maybe they haven't thought of it yet, then I can reach out to them and say, have you thought about doing this thing that I think you want to do? Here's how you can accomplish that.
Yeah. And so I am sort of first and foremost an acquisition lawyer, but I've been, I guess, focusing on space for the last 8 years of my career. And so I'm working in the General Counsel's Office division focused on within the Department of the Air Force, focused on acquisition. Our client, the ultimate client is the Secretary of the Air Force, but it used to be one presidentially appointed Assistant Secretary of the Air Force for acquisition, technology, and logistics. So it was in charge of all acquisition within the Department of the Air Force. Now, since the stand-up of the Space Force, they've created a second Assistant Secretary of the Air Force focused on space acquisition and integration. And so that official and their staff are sort of the primary clients that I'm working with on a day-to-day basis. And that official is responsible for overseeing all of the acquisition programs within the Department of the Air Force. And they tend to make kind of key decisions on the programs. They make milestone decisions for where a acquisition program is coming up for kind of a big review. Congress has created a fairly rigorous program management structure that needs to be complied with for really large Department of Defense research and development programs, and that requires sort of very high level approvals for kind of key moments in an acquisition. And so, our office and myself reviews and advises that official when they're making those decisions. Also, just all of the business of awarding contracts. If you get disputes about the award of a contract, source selection decisions, we get bid protests where litigation is brought to challenge, whether or not the award was fair or, something else was done improperly. We advise on that and work with the litigators who are then going to actually be, there's a different division within the Department of the Air Force that actually does the litigation on a day-to-day basis. But when it's something that's sort of a very kind of high interest item for the Secretary of the Air Force or one of the assistant secretaries, we're often involved and helping kind of bring the General Counsel's office kind of in the loop and making sure that kind of the department's leadership's equities are, being kind of well served by whatever it is that we're doing, in the litigation. So I would say what kind of brings me in contact most I've found with the sort of the true space lawyers that do kind of space law as, the law of like what we can do in space is often when we're doing kind of commercial services in space, or kind of as sort of commercial space has grown and taken on a kind of a bigger role within what the Department of Defense and Department of the Air Force does with space. What we're doing in space then gets reflected in the contracts and what we're awarding, and kind of becomes an acquisition issue, or brings us, in the loop. And so, I find often when we're working on commercial space issues, be that, communications, be that launch, especially because of the way we buy launches, I'm often, on the phone with, Deb Plunkett or Bart or, their analogs, talking about kind of the operational issues. Because it becomes kind of interdisciplinary between the acquisition folks and the space lawyers.
Thank you. Well, so far we've, obviously been looking very much from the DoD perspective, because most of the representatives here are within DoD. James, what does national security space and space operations look like from your viewpoint, from the commercial side, the non-government practitioners?
It's been a very interesting couple of decades, and I've had the privilege of watching the evolution of the commercial launch to national security sector grow and evolve as the commercial launch sector actually became something real. And we started out with the national security sector having no idea whatsoever what to make of the commercial launch people, mostly worrying about whether we would interfere with their operations in some way. An interesting conversation with a Navy guy at the Pentagon in the early years when I said, well, we're going to launch from sea and we want to avoid hitting any of your aircraft when we launch a rocket. And he said, we have a hard enough time shooting down an airplane with rockets on purpose. If you manage to do it, let us know how you did it. But normally they were a little more serious than that. But anyway, and they didn't know what to make of it. The '84 legislation allowed commercial launch companies to go on the national ranges and launch from a fully reimbursable basis. And of course, we had to comply with the entire set of range rules and safety practices, which in a way was good because it made the FAA easier about giving us a launch license, or to know that we were complying with 127-1, et cetera. But it was we had this very interesting couple of years, and I was managing the interface with Vandenberg at that time for about 3 years. And, they kept wanting to treat us as a contractor. And I would keep having to say to all these, they're basically positive-minded people and wanted to see the mission happen. And I'd say, well, we're not a contractor. We're not taking federal money. The thing you asked us to comply with is a condition of a contract, and we don't have that contract. We have a launch services purchase agreement where we're the buyer and you're the vendor. And you're the landlord, so you can impose conditions on us, but this has to be rewritten. They loved hearing that,
We're very, very.
this was it. We had to go on and pioneer how to be a commercial customer of a national range. And it was a learning process on both sides, but there was actually a huge amount of goodwill from the people on the bases, because they really wanted to see things happen in space for America. And they were frustrated at the way the government-run programs were going. So they saw this as hopeful. And that was at the working level thing, but it went up to the commander, who was Colonel Earl Severo at that time. Very positive individual, really wanted to make things happen. But it took a couple of decades before people like Musk, started to launch the Falcons and started to have a track record. And then all of a sudden, not all of a sudden, but the defense sector had been buying legacy rockets from the legacy contractors for a couple of decades. They were using the rules and precedents and legislation that the commercial companies like ourselves had pioneered when, Challenger went down and, so many payloads had to be offloaded from the shuttle and go back on expendables. That infrastructure and the legal infrastructure and the contractual infrastructure was already there. So it was a matter of eventually, you had kind of what I would call the equivalent of the Jones Act Merchant Marine in the launch sector. It was, it was expensive. It was limited by circumstances to a small number of providers, and it was kind of a comfortable groove for the legacy people. And eventually, they all coalesced into the United Launch Alliance, but it was not competitive on the world marketplace. So SpaceX and then the other companies that have come along, like Rocket Labs, have started to upend that paradigm, and it was about time. We finally get in the launch industry that we had envisioned when we first started creating the pioneering private companies in the 80s. And at that point, it became a matter of this is close enough to being an actual commercial marketplace that you can come in and buy a known quantity at a market price. Yeah, we're not quite there yet, but we're a long way down the road to that point. And it's been greatly to the benefit of the national security sector. But now we have a whole set of new issues that are arising and also new opportunities that are arising because, first of all, you have many more launch options and they're a lot cheaper. And I would hope that you're finding the commercial operators are pretty willing to, work with you guys and meet your specific national security needs. And I think that in the future, the commercial launch sector is going to be a permanent feature of national security planning the same way civil airlines are to military aviation planning, or the merchant marine is to naval planning. And I think the interesting challenge from the legal standpoint is, can we arrive at permanent mechanisms for that interface and the interoperation equivalent, say, the Civil Reserve Air Fleet in aviation, or the equivalent merchant marine availability legislation, I forget the name of the act, that the US uses, or that you saw the UK use so successfully in the Falklands War, when they were able to start, converting liners in 48 hours from the call going out. Now, obviously, the mechanisms are going to be different. The way it's going to look is going to be different, but it's the same intent. Let's use this commercial sector. And on the other hand, I have both a hope of seeing a much more robust commercial launch sector because it's also meeting national security needs. I hope that it's not loved to death. In other words, that in the course of making it suitable for the national security needs, you don't start imposing costs and changes and such that start rendering the commercial sector uncompetitive on the world marketplace. Because right now, SpaceX is dominating the world market very successfully. That's not going to last forever. It's going to be a real horse race as the other nations start learning this stuff. I mean, the Chinese started licensing private launch companies in 2015. And there's like 20 to 30 of them, at least that I can tell. And they have no safety or environmental regulations that they seem to need to comply with. So, it's going to be an interesting world. But I think it's also a very hopeful world. And this also applies, since I'm working spaceport issues a lot right now, to the spaceports, because right now, we have a collection of private spaceports that are mostly the result of an ambitious local economic development authority somewhere, or some ambitious state legislator or something that came across as very haphazard set of installations. Some are successful, some are really spaceports in name only. They just have a license and nothing ever happens. That's no way to run a facility for capability that's going to become more important to the national security. We need to think through and I'm circulating a draft article, which I hope to see published soon, towards a National Defense Reserve Spaceport System. And we can start looking at under what conditions can we do orbital launches from a low population density area, spaceports inland, or how to convert some of the things that are right now purely commercial and underutilized into something that we could rely on in a national emergency, especially as the constellations become critical to communications and maybe remote sensing for the military. As opponents try to degrade these systems by taking satellites out, replenishment becomes a critical need. Replenishment means replenishment from spaceports. If we only are using 3 national ranges, the opponent's going to look at the thing and say, the weakest link in this whole chain is the spaceports. If we can shut them down by one means or another, we've stopped the whole replenishment. If you have, what do we have, like 20 licensed spaceports in the United States right now, most of them are, barely functional. But 2 or 3 are quite functional, like Kodiak. You can start playing whack-a-mole, or you can say, no, we've got 30 places we can replenish from. They're not going to shut all 30 down. So that's a lot more resilience. So that's a big agenda, but I think that it's going to be a very interesting decade. And those are some of the things that we could be giving serious thought to.
Well, to follow up on the whole participation and utilization of commercial capabilities to provide both capabilities and services to the national security space activities. Bart, could you address a little bit what the legal considerations might be for using commercial companies by DoD and for national space?
Sure. So obviously, one thing we would need to be concerned with is if we're going to use a commercial provider, is that commercial provider, if there's a requirement for any classification matters that we would need to comply with that. Is the commercial provider going to be sufficient if we get into a competition, for example, with the U.S. versus another country? I guess that could be a concern. Let's see. I don't know. I didn't know that question was going to be aimed at me.
Okay, I can jump in, and I'd say some of the things.
Go ahead,
this
please.
is something that I know we've been kind of thinking about a lot within the Air Force. As the Department of the Air Force buys more, commercial space services and using those things for sort of critical kind of no-fail sorts of missions, thinking about, well, what should we be concerned about? And thinking about, well, what should we have in our contracts? And I think there are certainly concerns. I think about, I would say, sort of reliability, just sort of as a very kind of general matter. And I would kind of lump under that term things like, is the company going to kind of be there for us, in our time of need? And that might be, are they, reliable from the standpoint of, do they have some sort of ulterior motive or something like that, where we maybe, we need to trust them and we use controls, like sort of foreign ownership and control type checks to make sure, we're maybe awarding to U.S. companies or, things like that to make sure that the company is going to, not have an ulterior motive, besides making money and fulfilling its contract. I think another thing that, we think about, kind of recently is, as sort of space, kind of as a warfighting domain, if, we're using these, companies to provide military services, those companies might be attacked, and what sorts of assurances might, a company, even if it's, totally on board with whatever the US, mission is, if they're, putting their constellation at risk, something that might bankrupt the company, what sorts of assurances, would they maybe want in a contract, or maybe some sort of other legal regime where, maybe they're indemnified, or maybe there's something, maybe like your point about sort of like a civil reserve type fleet, maybe, some sort of a similar structure like that for, space that contains, something like that might be appropriate. So I'd say those are kind of some of the things that I think we're thinking about right now in terms of, as we're using commercial services increasingly in the national security domain, what are some things that we ought to be, thinking through?
Todd, I'm going to ask the question of you in a slightly different way. I think you're familiar with the article that David Coppola published in the last year, basically saying that the utilization of commercial capabilities in conjunction with national security space was actually a violation of international law. Would you, do you want to give a quick comment about that?
Sure. For those of you who aren't familiar with Professor Koppel's argument, he makes an argument that we are violating a principle of reverse distinction, I think is how he puts it, that by using commercial providers for all these national security functions, we are putting civilians and civilian objects into a military purpose, making them object of attack in a manner inconsistent with our obligation of distinction under the law of war. I think that, for starters, I think one of the shortfalls of Professor Koppel's article was he pointed to the Navy and said the Navy does all their transport on gray hull ships, and the Air Force does all its movement on gray hull planes, neither of which factual predicate is factually correct. I think the large volume of Navy material moves via contracted vessels, and that's certainly true as well for military airlift or airlift in support of military forces. Most of it is on commercially provided aircraft. Certainly, if a civilian company is providing services directly in the middle of a military operation, if they're bringing in the food for the soldiers, in the example of civilian airlift, or say they're providing communications, they may become a lawful target depending on the nature of their involvement. And that becomes a part of the consideration of how the contract is structured, like Damon was getting at. That's not novel to space, though. That's the same considerations that we have with the food service contracts in Afghanistan, with the fuel contracts in Iraq. All contracted military logistics face those same considerations. There's probably a point where commercially provided services may cross a line and get into something that would be most appropriately something for a privileged belligerent, is the term of art for a uniformed military member. But that's getting into use of force type matters, where we are using force in international conflict. And that's not how we employ commercial services in national security space. There's lots of value in commercial services well short of that threshold of the use of force in conflict.
Thank you. I have a few more questions I could ask of the panel, but in the interest of allowing the folks here to participate, I think if we start now with questions, we give them about 20, we have about 20 minutes to do questions. So.
Good afternoon, Bethany Johns from the American Astronomical Society. So the conversation earlier reminded me of some of the things we were fighting against and what ultimately became the CHIPS and Science Act. in which CFIUS was going to be invoked for how we were going to work with China in some of our research capabilities. And I was thinking of that as like as commercial space operators and satellites are become more and more available, like how much of what the national security institution uses is going to be made in China. And there were provisions that we fought against, was like, you couldn't use like drones in research that had microchips that were produced in China. So how much is CFIUS going to be involved in this process of understanding where the national security can purchase from commercial operators that maybe are outside of the United States, foreign operators?
I can.
Damon, I think
can
you're the
maybe start
perfect
with that.
candidate.
Yeah. Well, so I think I'm not a CFIUS expert, but I sit a couple offices down from the person who does CFIUS stuff for the Department of the Air Force. And I'd say for space launch in particular, there's a special statute that requires that the federal government buy launches as a commercial service from US domestic launch providers, which I think the statute defines that as a sort of majority US ownership of the entity. And so in terms of like launch, certainly we're required to always buy from a US entity that's doing our launches. Now, in terms of CFIUS involvement, CFIUS, they essentially, as best I understand it, I mean, they look at transactions, and so anytime you've got a merger or an acquisition, in the space domain, I would probably expect that there would probably be a CFIUS case that would look at that and say, is this something where we feel like it ought to be blocked or not? That sort of exhausts my CFIUS expertise, but I think that there is interest certainly anytime there's a merger, an acquisition involving space companies. But CFIUS isn't going to, I think, do everything for us because again, it's limited to kind of acquisitions, mergers. If you have a company that is domestic or that isn't buying or selling or something like that, that's not something that's going to trigger a CFIUS review and isn't going to kind of capture whatever concerns we might have about foreign ownership or foreign control or ulterior sorts of motives that a company might have.
So Damon, if I may quickly
Yeah.
interject, besides CFIUS, you also have the Buy America Act, which has a significant impact on national security enterprises, space enterprises' ability to buy anything with that's not.
Yes,
by an American
absolutely.
manufacturer.
Yeah, so we, I guess I'd say sort of two things about that. One is there are exceptions if something can't be bought, with domestically, there are exceptions that can be invoked for that. So if there's some sort of technology that's sort of only being made in China, the Buy America Act isn't going to sort of do much for us there, although perhaps it'll incentivize a domestic provider, but that doesn't always happen. But then I would also say the Buy America Act is focused on goods and physical products and not on things like services. And so depending on how we're buying things, if we're buying launch as a service, if we're buying commercial communication services, the Buy America Act isn't going to reach those transactions and say you have to buy from a domestic service provider because we're not buying goods at all, and so it isn't triggered. And so there would have to be other laws like the special launch law or something else that would mandate a domestic source of the services.
Yeah, Damon, David Silver Spaceport. So you're talking that DoD is going to buy from US companies, I can understand that. But what if the individual, say the CEO or the CFO, is a foreign national? He might have a green card, he might have a work to right. I mean, work to be able to work in the United States. There's all kinds of immigration laws that come into play. How does DoD look at that? And are they mostly concerned with the effect of the company being a US company, or are they looking at the actual executive powers of the corporation?
So I would say it's both. In terms of complying with the law and buying from a domestic provider, we've got to check that box. And then, but I don't think that ends the inquiry in the case you highlighted. And I would say there's a couple different things that we would look to. I mean, I think the first would be a contractor responsibility type inquiry for federal contracting, everything, space, not space, across DoD, across all federal government. All contracts must be awarded to an entity that's deemed to be a responsible contractor. And if a company has proven itself to be an unreliable business partner, they defraud some aspect of the federal government, they have practices that aren't consistent with what they're saying they're supposed to be doing, even if they're just not as financially responsible or solvent, and we're worried that they're going to go out of business. All of those types of things are rolled up into contractor responsibility determination. So if we had a company that had a CEO or employees that we felt like were not reliable in whatever ways, that they might get a department or a suspension, or we might look at that as a possible approach to addressing that. And so, I mean, I think that would be kind of the main way that we would probably look to addressing an issue where we felt like, yes, the company is, like the company itself might be fine, it's domestic, but they're not going to do what they promised to do, and we can't rely on them. Then we'd probably be looking at contractor responsibility as a possible approach.
Despite the limitations you just mentioned of being able to engage within the international community on this commercial side, what are some of the maybe interesting things that you've seen that the new Space Force acquisition is setting standards for the entire world? Are there interesting programs through the Quad or NATO? Some like exercises, like I heard like the Shriver Games, for example. What are some of those international setting standards is making this military commercial standard global? You would see.
Yeah, I can.
I'm going to ask
Yeah,
Todd. Todd, if
absolutely.
you can talk a little bit about the international engagement that you're seeing through SpaceCom.
I can talk a little bit about international engagement. I'll know a little less about acquisition reforms because that's mainly happening on the service side and at the service level. And I've served at the field command levels. But Space Command, like all combatant commands, has a high premium on international engagement because we never operate alone. On orbit and terrestrially, we've got allies and partners that we work with, and we've got other nations that we partner with for any given activity, because you need eyes in the sky from a certain vantage point on Earth, because we've got a mutual interest in whatever the activity is. So we've got a number of foreign officers actually running around Space Command that we have embedded in the organization. And we've got a number of our officers embedded in our different ally and partner nations where we do operations and where we operate together. One of those is actually it does have I'll mention this one because it does have an acquisition aspect to it, is commercial space domain awareness information, which one of our components is starting to undertake, because they can procure SDA information, space domain awareness information commercially, free of the taint of the intelligence community. it's unclassified when it comes in, so we don't have to get it declassified. We don't have to deal with no form limitations and the like. And that enables us to create products that can be shared with allies and partners. There's an effort that's underway to establish different centers in different time zones. So we've got 24-hour coverage as the world turns, and these different commands take shift. And the Meridian Cell has started operations in the UK. There's another that's contemplated in Australia. There's efforts to work that, but that's sort of an intersection of how Space Command is leveraging a commercial to simplify a task that's very important and is made easier and better when we don't get it from our own intelligence community. We still get that for intelligence purposes, but when it doesn't have to have the additional complications, in this case, it's better to buy it from capable providers.
Tried to get it turned on again. Thinking about the earlier conversation around purchasing services rather than systems, I think there is a risk there as we leverage more and more commercial capabilities, and the value of those capabilities continues to increase, that you're going to run into a condition where they cannot afford to continue to support in the time of a conflict, and you can't afford to indemnify them if there were. You think about a constellation of 40,000 satellites. If those are put at risk, it's not like flying airlines overseas into a war zone or contested zone where you're potentially liable for a plane or two and a crew. And you also don't have the ability to stand up the infrastructure and personnel to go take over control of those assets when you have that larger constellation. So there may be a tipping point where you can no longer force or take over control. And I'd be curious on the panel's thoughts on that.
Yeah, so I'd say I absolutely agree that, and I think what I would say is I think it's critical that we think through these things now, sort of before we're in the thick of it, and figure out, should there be a limit to how much we're relying on commercial services for certain types of activities, and thinking about, what do we need to do to kind of make sure that the company is going to be, protected or made whole, and, does that look like a Civil Reserve fleet for space? Does that look like, something else? But I think, I think those are the right sorts of things to be asking about. And I don't think we have the answers yet.
Well, I will say that there is, in fact, that's part of the discussion in the acquisition, in considering how we're going to acquire capabilities. Part of the calculus is it a contractual matter, or is it something that needs to be integral to the department? So it's clearly part of the dialogue. Yes.
Hi, Laura Montgomery. My question is.
Can you turn on your microphone?
Close to your mouth.
Hello. Okay. My question relates to something a little further out. How do any of you on the panel see the actions of China in the South China Sea as having parallels for its plans for the moon and activity there? And do you see any legal implications that might translate across the vast divide, or not? So thank you.
That's a great question, Laura. China's done a lot of stuff in orbit and terrestrially that raises concerns. And if you're not familiar with their activities in the South China Sea, I'll give you a short example. Mischief Reef is a low tide elevation. It's not even above water all the time. But China dredged up land, built a military base on it, and as a practical matter, asserts maritime claims based on their presence on Mischief Reef. There's no basis in international law for such a claim. It violates principles of UNCLOS. They were taken to the International Court of Arbitration about it, didn't show, lost the case. Everyone said you can't do that, it's against international law, and yet China is still on Mischief Reef with a military base that they built there and is still occupying it. So I think that that is a very concerning thing to behold. That sort of thing is replicated in a number of other locations around the South China Sea, and that idea, as it were, of just a disregard of what is otherwise acknowledged as a legal norm or a legal obligation is of concern. So knowing that China has a great interest in lunar activity and looking at what our space treaty says about non-appropriation, I can certainly imagine a situation where China were to get to the moon and stake a claim, assert a claim, whether in words or deed, that would raise the question that's been raised a lot of other places of what do we do about it? More broadly, the whole Outer Space Treaty Convention, the whole Outer Space Treaty framework, it's been valuable, it's been very persistent, but it is not a guarantee. It's not a law of physics. It's got to be, like all provisions and principles of international law, it's got to be safeguarded when it's challenged. And so that's part of why we need to be on the moon. We can't challenge someone who is challenging the rules of international law and who's violating international law. We can't challenge them if we can't get there and we can't operate in that space. Now, how do we compete with the South China Sea or in the South China Sea? We're not invading, right? But we are sailing through there. The Navy will do freedom of navigation operations contesting those maritime claims so that they don't take hold through the law of the sea version of adverse possession. And I think there's a good argument that China may view the law of adverse possession as a descriptive law of physics instead of an enacted principle of law. And if by their actions they've demonstrated they are willing to break the law, if it means they can hold a thing that they value.
Stephen Fleming, University of Arizona. Not here to ask Elon Musk questions all afternoon, but I'm going to ask another one. So Elon's got a network of 3,200 Starlink satellites in orbit right now. They have cameras, they have propulsion, they're independently targetable. That's a dandy anti-satellite military network. Those could be weaponized. I guess it's a two-part question. What do we think about a private actor having that sort of military capability? And are there any plans to press that into national service like the civilian reserve fleet if we suddenly need them one day?
I'm not sure any of our one of our panelists want to answer.
I'll take a stab at it, but I've been talking a
Okay.
lot.
Well, I will, however, make a disclaimer that this is not, this is in your personal capacity, not.
No plans along those lines, but many things in space have a dual function. Anything that's maneuverable can have an anti-satellite function. Any on-orbit servicing capability could have an anti-satellite function. Any debris mitigation capability could have an anti-satellite function, and that becomes some of the international complexity of getting buy-in for those important capabilities. No plans to employ Starlink like that. When I think of Starlink and mega constellations like that in the context of anti-satellite warfare concepts, someone asked one time if, Starlink's become very important in the conflict in Ukraine. What if the Russians were to shoot down Starlink satellites? Well, I mean, you can't shoot one down for less than you can put up 40. So the kinetic threat for that that constellation is resilient enough to withstand kinetic action. Now, there may be other threat vectors to Starlink or other mega constellations, but they bring with them a measure of resilience against at least kinetic threats.
And
Anyone else? Yeah.
just add to that, the idea of anti-satellite, I would note that the the vice president announced back in earlier this year, in April, that the United States commits not to conduct any not to conduct destructive direct descent anti-satellite missile testing. So we're trying to lead the world in avoiding that sort of debris creating issue. So that would it's not directly on point, but it augurs against the idea of employing a whole fleet of ASAT systems. Thank you.
Last question, I think.
Oh, good. This will be great. So hi, John Daigle from the National Space Society. This may not seem like a national security issue at first, but it will. I'm here apparently to ask planetary defense questions all day. And I think we can all agree that planetary defense is a good thing. However, Carl Sagan opposed a lot of planetary defense efforts on the basis that if you can redirect an asteroid that's going to hit the Earth, then you could also redirect an asteroid that is not going to hit the Earth as a weapon. So I'm just curious whether any of you have thought about that or would like to comment on the national security implications.
I don't think there's a single science fiction reader or writer who hasn't thought about, that particular scenario as how to start a dramatic science fiction attack of Earth scenario. So
I would comment on an interesting legal issue related to planetary defense, and that's the use of a nuclear device. Of course, is one of the possibilities that could redirect or blow up the asteroid coming in. And the Outer Space Treaty prohibits the placement in orbit of nuclear weapons. So is a nuclear device that's intended to blow up, used for benevolent purpose, blowing up an asteroid, is that a nuclear weapon under the Outer Space Treaty and therefore prohibited? There's not an official government position I'm aware of. If anyone consulted me, I think I could make an argument that it isn't. There's also a question of whether would that have to be placed in orbit, in Earth's orbit, in order to fall within the restriction under Article 4 of the Outer Space Treaty.
I think on that, I would quote Special Operations Emergency Medicine Dr. Pete Bennett on this. You got to survive the gunshot wound before you can die of the staph infection. If an asteroid's going to hit the planet, we probably best have an option to do something about it, and then deal with how we regulate the capability as a important but possibly secondary matter.
We have a comment too.
Yeah, just to follow on to Bart's reaction, I don't think, strictly speaking, for the reason that you indicate that the Outer Space Treaty is the problem with the nuclear explosions. It's the Partial Test Ban Treaty, which prohibits any nuclear explosions, whether of peaceful purpose or otherwise. That's the one we would need to be concerned with if we think about the possibility of using a nuclear explosion to sort of change an asteroid's course or keep it from hitting the Earth.
Agreed. I mean, I guess I raised the Outer Space Treaty because it's the most easily answered. I have read, there was Dave Koplow's name was brought up before. He wrote an article with the idea that if this was really going to happen, we would go to the UN, and the UN would say, "Yay, verily, go blow it up," and that would get us past the non-compliance with treaty concerns. I think that's along the lines of what Todd was saying, is we're just going to get it done. And so, anyway, and John, I think you.
Well, 2 points now. One of which is, yeah, we would go to the UN. If they said no, we'd do it anyway. The second one is whether it could be used as a weapon against somebody else on Earth. I think that was the same reason we haven't seen much biowarfare being used, even though the capability has been around for a long time. It's too hard to control the blowback. It's too hard to say, are we sure it's going to land on them and not us? And the second one is, exactly how small of an asteroid does it have to be to avoid a catastrophic nuclear winter or some other undesirable effect? And unless you're some kind of wacko doomsday cult, that would probably be enough to deter any rational actor from trying it.
I think,
Yeah, unless there's any more
unless
questions.
there's, well,
Don't open the door like that.
One more, if there is one, but otherwise.
all right, well, thank you all. Thank you to the panelists.
So, what a day. Fascinating. I was worried that the final session involving national security would have no conflict, but that evolved in a different direction as our conversations continued. So the title of this gathering today was "The Future Almost, Now," but I think we got a lot of now, increasing through the day, of issues that are very current, not just coming. And I think in this room, not just on the panels, and thank you, this was a great panel. Every panel has been spectacular, but the interplay here of folks in government, all branches except the judiciary, civilian and military, nonprofits, academics, and in commerce and in business is illustrative of maybe in some ways pretty striking and unique about this area. Let's include academics, but notice the relatively modest role of academics in these discussions. And that point has come out too during the day. There are 4 space law professors here in the room, and they helped shape these panels as well. Friends, Laura, Michelle, and Chris, I believe, are the only who spend their time teaching JDs in the area. It leads to some interesting questions for me as a dean, for the U of A, for other universities, and then for those who today heard the call for more discussion of space law and policy, not only from a legal, but also an economic and historic and other perspective. We didn't hear a lot about research. We heard calls for research, which, by the way, is always music to an academic's ears. At lunch, in the conversation with Chris, Alex McDonald made the point, I think there are enough space lawyers out there, but we just need more historians and others. And I went up after to talk with him about that. And I think he quickly changed his view. It strikes me that today, one of the things we heard on both the public and private side is the need for a lot more people with at least exposure to the vast range of issues around space law, not necessarily more trained space lawyers at the JD level. I mean, that's an interesting question. Do people come to law school to be trained? When do they get excited? As best I can tell from every space lawyer I've talked to in here, that interest and expertise developed largely after, if not completely after, the time in which they had their JD training. But it does lead to the very interesting question of if and how we make training to enable lawyers in a variety of settings to contribute to the very interesting conflicts and discussions that were just illuminated. One small slice today, by the way, on the historic foundations of space law. I have told a few of you 2 days ago in Mexico City, I held an original edition of Hugo Grotius's On the Law of War and Peace, Law and War and Peace. And if only I could read both Latin and Greek, I would have spent more time with it. But I wanted to end today with a couple of comments. Just one, thanks again to Chris, Brew, Janelle, Carla, and everyone at and outside the U of A who helped think this through. As I said up front, and I hope as a full disclosure, we didn't come to U of A Law School, right? The U of A has deep foundations in space science. We didn't, and in astronomy, but we didn't come as experts on space law, but instead invited so many of you to help us and frame this, what I thought was a fabulous set of conversations today. So thanks, all. Second to all panelists here, and before, stay for at least a few minutes, because we have a small gift for you as a thank you. And one more comment and then a thanks to all of you. The other comment goes to China, the very interesting China discussions we've had. My comment does not go to the national security issues. I don't only claim no expertise, but there are lots of people in the room much more attuned to that. So I am not a national security lawyer. But my College of Law has more Chinese students studying with us in Qingdao at Ocean University of China, getting a dual undergraduate degree in law than we have JDs in the 107-year-old program. 475 this fall, 500 next fall. I suspect that when I talk to our partners in China, and it has been a great partnership, it has not been buffeted by the winds of US-China relations. If anyone's interested, I'm happy to expand on this. It has been a great partnership. I suspect if I talk to our partners and say, would you be interested in us teaching space law? They will very quickly say yes. And all of a sudden, there will be hundreds of young, very high quality, young lawyers in China exposed to some of these issues. I view that as a constructive contribution, as I do our program in China generally, but given the importance of China in these broad conversations, I thought that was worth mentioning. It goes to a bigger point, which is that many of the people who should be trained in aspects of space law are not, in fact, lawyers. They don't have to be. And that the ability to train and engage folks in business and in national security and elsewhere for whom deeper study of space law, of the treaties, of the structures, of the nonprofit engagement, of the conversations, of the efforts in the UN, of legislation that we've been talking about would help to inform and shape that in industry and elsewhere. And that is an emerging trend. Again, U of A, we have more students, 475 master's students, non-lawyers, studying 95% online, mostly outside of Arizona. No space law, Franz, let's talk. Or Michelle or Chris or, but the potential to shape either the undergraduates, 1,700 of them, 475 in Qingdao, right? But many in person in Tucson, or other professionals at a different point. That may be the way to push forward and deepen the quality of the conversation around the very interesting and challenging issues we've heard. And as a dean and at the U of A, this is one of the conversations we're engaged in. I welcome input from all of you on that topic. How can the U of A contribute not only as a world-class astronomy and space sciences, but in these conversations, law policy? And I just want to say, from my standpoint, hearing the fabulous questions from so many of you, some of you panelists, but many really, thank you for taking your time for what I really thought was an extraordinary day. And that thank you extends to all of you. And with that, we are done.